Rationale. It's Professor Tracy back with another contracts video. This one is on a defense. This one on the defense of incapacity or lack of capacity. So we have been working our way through an analytic framework that deals with the entire subject of contracts. We have thus far spent the vast majority of our time looking at contract formation, and we're moving on to defenses and started to do so with a look at the Statute of Frauds. And after defenses, we'll look at contract interpretation and implied terms, and look at breach of contract conditions and repudiation. And then we'll finally look at remedies. Why are we all doing this? Obviously, we're doing all this in order to get a remedy for ourselves or for our clients. So it's obviously important. So with formation, our focus was on offer acceptance and consideration. And then with defenses, we're going to be looking at two different kinds of defenses. We'll be looking at defenses to formation and looking at excuses. The difference being that defenses to formation occur, as the name would suggest, at formation, meaning there is something that goes wrong, there's a defect in the formation process, whether that be a failure to comply with the Statute of Frauds or the fact that one of the parties lacked the capacity to contract, or maybe there was some amount of coercion or undue influence or duress involved. That's what we mean with a defense to formation. It's something that occurs at formation, which provides a defense and likely invalidates the agreement. Then the other thing here with excuses, when we talk about an excuse, what we mean is an event that occurs after formation that excuses one or both of the parties from having to perform. So it excuses a party from performance, but it's an event that occurs post-formation. So our focus for now, though, is on the first of these kinds of defenses, those things that occur at formation. And as we said, we've looked at the Statute of Frauds, and yes, that's something we need to ensure compliance with at formation, or be cognizant of, recalling that the writing need not have been around at formation, but it's something we need to be cognizant about at formation. But it comes up practically in terms of a defense, is a failure to comply with the Statute of Frauds. And this time we're looking at lack of capacity. So meaning that they lack the legal capacity to be able to form a contract. And so any contract they tried to form would be void or invalid. It could be disaffirmed. And so why would we do this? We do this because we want to protect individuals that we deem to be incapable of protecting their own interest. And so we provide a mechanism for them to seek protection in the law against enforcement against a contract that may have been ill-considered. So who is it that typically lacks capacity? There are three different types of individuals. So we have minors, or what the common law is called infants, so anybody under the age of 18. We have mentally incompetent persons, and then intoxicated persons, assuming the other party to the contract had reason to know of the intoxication. So those are the three bases of lack of capacity. What are the consequences if somebody is a minor or is mentally incompetent or is intoxicated and the other person had reason to know of it? Well, the consequences, this being the first and foremost and the biggest, is that person who lacks capacity has a right to disaffirm the contract, The other thing to know is that if somebody retains the benefits of that contract after gaining capacity, meaning if they were a minor, now they've reached the age of majority and they retain the benefit of the contract, they are ratifying that agreement. By ratifying it, that means the defense is gone. They've ratified that it's valid. If it's somebody who's intoxicated and they are now sober, they've sobered up and they've decided to retain the benefit of that contract, that again would be a ratification. The same thing would be true if someone was mentally incompetent. If either if they themselves have intervals in which they are lucid, then they could ratify the agreement at that point by retaining it. Or if they're retaining it, say they have a guardian that's looking after them because they're mentally incompetent, then the decision by the guardian to just retain the benefits of that contract would also be a ratification. And finally, the other consequence is if the contract is about what we term under the law as a necessary. Necessaries are food, clothing, shelter, medical care. Those things, if that's what we're referring to, then while the contract can still be disaffirmed, the person who lacked capacity is nonetheless liable in quasi-contract or restitution for the value of those goods or services that are deemed necessaries. So let's start with looking at this first consequence, the right to disaffirm by a person without capacity. So here's an example. We've got Bob, baby Bob here, and Bo. And baby Bob says he's going to wash Bo's car, and Bo's going to pay him $30 for doing so. And Bob, surprisingly, baby Bob breaches that agreement. Now, if Bo sues baby Bob for breach, then, and remember, that's okay. There's nothing wrong, and you'll understand in a minute why I'm emphasizing this. You'll understand better. The fact that Bo is seeking to enforce the agreement is okay, but recognize that Bob has a defense. He's raising the defense of minority, right? He is a minor, and so he can raise that defense, and if it's valid, it's a valid defense. Here, he's clearly a minor. He's still a minor. There's no benefits been given to him. He hasn't ratified it in any way. So he's disaffirmed the contract. He's free to do that. He can raise that as a defense. It's that straightforward. What about another example with baby Bob and Bo here? Baby Bob says he'll wash Bo's car again, and Bo says that he will pay him $30 for doing it. And this time, Bob performs. Bob washes the car, and that means his duty is discharged, that his part of the contract's fulfilled. And Bo decides while he has the money, he's just going to keep the money and not give it to Bob. Therefore, he breaches his obligation, his duty to Bob to pay the $30. And so baby Bob sues Bo for breach of contract, and Bo tries to raise the defense of minority. After all, he made a contract with a minor. Shouldn't he be able to disaffirm it? And the answer is no. It's only Bob. It's only the minor, the person who lacks capacity, that can assert the defense. So while Bob can raise a defense, as we saw in the first example, Bo cannot. So that's not going to work. So what would that mean? That would mean Bob would be able to proceed with his lawsuit in that case. So what about this second consequence we pointed out, that there's this implied ratification if you retain the benefit after regaining capacity. So example 3 here, and again, this carries across. Now we have teenage Bob, right, or pretending. And so here they form another contract, this time for the purchase and sale of a car. And so Bob is promising to pay $5,000 plus 5% interest, and Bo is promising to deliver Bob a car. And Bob breaches. Again, he has the money, but he doesn't pay it over, right? So, but he keeps the car. right? And so he's retaining this benefit. And then Bob turns 18, right? He doesn't like the responsibilities of being an adult. So here he's got it, and he's continuing to retain the car. So he's no longer a minor. He's reached the age of majority. He's decided to retain the benefit of his contract with Bo, but he's in breach, right? He's in breach of that agreement. So we can say he has ratified it, right? Given up any defense he would have for lack of capacity, because he was a minor, but he ratified it once he became an adult by retaining the benefits, right? He says, I have no complaints or objections. In fact, I love my car. So here, Bo even recognizes it, right?
I believe dear little Bobby just ratified our contract.
So Bo sues him for breach of contract, and Bob says, I have a defense of minority, because keep in mind, that would work assuming he hadn't ratified it. He would be able to disaffirm it for a reasonable time after reaching the age of majority, because the rule is he can disaffirm it anytime while he's a minor or for a reasonable time after reaching the age of majority. But here, what the trick is that he retained it, right? He continued to use the car and he implicitly ratified it. So he doesn't have a defense. He can't raise it because he ratified it. So as Bo says, it's time for Bobby to pay up. So what about necessaries and quasi-contract liability? Example 4, let's look at this. So here, Bob is mentally incompetent, right? He's struggling with mental illness, and he enters into an agreement to rent an apartment for $1,000. And he has the money, decides not to use it. He breaches then with Bo, right? He's not going to spend the money, give him the money for rent. And then Bo sues him for breach. And then Bob raises a defense of mental incompetence. And we'll look at some of the nuances of the mental incompetence defense in just a minute or two. But for now, know that he can raise that saying, I lack capacity. I was mentally incompetent at the time I entered into the contract. And that would, in fact, disaffirm the agreement. So he can disaffirm it and he can say, I lack capacity, but the contract is for necessaries, right? Because it's an apartment. It's somewhere safe and warm for him to live. It's a necessary thing. So while he can't be sued on the contract he has with Bo, he can disaffirm that due to his lack of capacity, but there is still quasi-contract liability or restitutionary liability here for the value of that benefit. So that he's still on the hook, right, for the value, and he would have to pay Bo the value because it's a necessary. So what is you might say, well, what do you mean? What does disaffirmance look like? We need to think about it, because we've laid it out and said, well, we're just kind of canceling or voiding out the contract. But we need to unpack that a little more. So here we've got a drunk Bo, right? So here Bob's going to seize the opportunity to enter into a really one-sided lawn mowing contract with Bo. And so he promises, I will mow your lawn for $1,700. And Bo promises that he'll pay $1,700 up front. And so Bo performs, right? He pays him that money up front, the $1,700. And so that duty is discharged, and then Bo sobers up.
Right? I have vague memories of making a contract with Bob.
So Bo sobers up, right? He's now lucid and he's thinking he's sober, right? Though hungover, he confronts Bob and he says,
$1,700 to mow my tiny lawn? Are you kidding me? Give it back. I was drunk and you knew it.
Nope. Deal's a deal. It's not my fault. You were dumb and irresponsible. So there he's saying he's not going to give any of the money back, right? He's saying I was intoxicated. And Bo says,
Fine, face the wrath of the Boanator.
and then he raises this, right? And we'll see that key to the defense of intoxication is this knowledge, right? He's saying, I was intoxicated. I lacked capacity at the time I entered into the agreement, and you knew it. You had reason to know that I was intoxicated. So he's suing to disaffirm. Now keep in mind the difference here. This is fine. The other situations we looked at is somebody was being sued for breach and they raised lack of capacity as a defense. But you can also use it proactively as a sword, right? Not just as a shield. I guess I should have made my icon here, my drawing a sword. But he can use it to say, please, I'm suing to disaffirm or to invalidate the agreement. And so he's proactively seeking to invalidate or disaffirm the agreement. And he can do that, right? He can do that. So here, he can do that proactively. But what does that look like? We said the whole point of this example is to unpack what does disaffirmance look like. And remember, to disaffirm means not just to cancel or invalidate the contract, but we want to rescind it and put the parties back to where they were before they entered into the contract. So they're pre-contract positions. And so to do that, we have to say, well, have we completed that? The answer here is no, because remember, while we canceled the obligation, Bo already paid $1,700 to Bob. And so they have not been restored to their pre-contract positions. Bob needs to give the money, right? So there is quasi-contract liability when we are disaffirming. If there has been performance by one or both of the parties, when we go to disaffirm and rescind the agreement, then there will be quasi-contract recovery to get that back to the extent, because the contract has been disaffirmed, it's gone. It does not provide any basis for recovery for either Bob or Bo at this point. But at this point, what we do know is Bob hasn't performed. He hasn't mowed the lawn yet, but Bo has. Bo gave him the $1,700. So in that case, what do we know? We know that Bo can sue to get that back because that's the value. It's cash, so it's pretty easy to figure out what the value of the benefit is, but he can sue and get it back, right? So that puts now the $1,700 is back in Bo's hands, and things are back to the way they should be. So there is this element, if necessary, of quasi-contract recovery if one or both of the parties has already performed at the moment, at the time we're disaffirming the contract. But there are some specific rules and exceptions that apply when we are thinking about each of these types of lack of capacity. So we said we have these three. Let's focus, take them one at a time, look at minors. And here, the first thing to know is they have only limited quasi-contract liability. So we saw that when things are disaffirmed, normally to put people back to their pre-contract position, there's some element of quasi-contract recovery. But if they're a minor, typically it's limited. How so? So here we've got Bob and Bo again, and we've got this purchase and sale of a car. Yet again, here, let's assume that he pays $2,500 of this $5,000 price, right? So you see it's ticked down there. The blue arrow now says $2,500. And Bo delivers the car. So Bob has given money, right? And $2,500. And Bo has given the car over to Bob. And then Bob is using his car, right? I love my sweet ride. I drive it everywhere. And then he breaches, right? He has the money and he says, I don't think I'm going to pay for it. So he doesn't want to pay the balance. He's breaching. And then Bo sues him for that breach. Bob raises the defense of minority because he is a minor. He did lack capacity. He was a minor. He continues to be a minor. He can disaffirm the agreement. And so it's gone. The contract is gone, but we're not done. If we're going to disaffirm it and rescind it, we need to put them back to their pre-contract positions. And what do we know? We know we're not complete. Haven't completed our disaffirmance, because what happens? Bo still has some of Bobby's money, as he says. And Bob still has the car, even though it's got some wear and tear on it now, right? He says it's kind of a junker. So let's take it a piece at a time, right? We've disaffirmed it. There's no contract for them to get. If Bob wants to get his money back, he can sue in quasi-contract to get the $2,500 he already paid back. And he can then get that. And Bo can sue to get the car back. And he's got the car, but realize it has wear and tear. It's depreciated. So the question we have to ask, if this was a normal situation and Bob wasn't a minor, the answer would be he would have to account for the value he derived from it, right? The use he got out of it, the wear and tear, the depreciation that he caused on the vehicle. He would have to pay cash to Bo in order to put the parties back to where they were before they were pre-contract, right? Because now he has a car that's worth less than the car he had at the beginning. He is not in the position he was pre-contract. But because Bob is a minor, he doesn't have to pay him anything. He just has to return what he has in the condition it's in, period. As he says, nope. You get back what I have. That's it. So what about this, though? We say, well, normally they don't have to pay quasi-contract. But if the minor's engaged in tortious conduct, then they do. And the two types of tortious conduct tend to be, one, we'll look at it, right? So the first would be this, is if a minor is misrepresenting their age, right?
Good day to you, kind sir.
So if we fast forward through our example, instead of stepping through each little part of it, he's trying to pretend he's older than he really is, right? So there we fast forward in time, and here, if we get to the stage of Bob raised was able to prove he was a minor, disaffirmed the agreement, we're now at this quasi-contract idea, and we're to the part, right? Remember that Bo sued in quasi-contract. He got the car back and claimed, but I didn't get everything, right? I didn't get everything. Remember, Bob got the $2,500 back he had gotten, but it wasn't everything. So what about this? Because he engaged in tortious misrepresentation, he is going to have to pay all of it, some of, whatever it is. I'm saying, well, does he have to repay all $2,500 that he got back? Probably not, right? Whatever value he derived from it, whatever it is. So he's paying him cash to represent that depreciation. So he has to pay restitution here, or quasi-contract recovery, for the value he derived from that car because of the fact he engaged in a tort. He lied about his age. But what about another type of tort? So here, going through this again, same basic setup where Bob's paying half of the $2,500, Bo gives him the car, and Bob uses the car. And now, though, he uses the car like a moron. Let's say he intentionally drives like a moron, he gets into an accident, and then we fast forward again to this quasi-recovery, right? See the car, it's all burned up. It's a burnt husk of a car. And he says, I get the car back. And again, look, it's all damaged. There's wear on it. Aren't you going to have to pay me for that? And the answer is, if that damage is caused by his intentional conduct or his reckless conduct, his tortious conduct, then he would have to pay for it. So again, some amount of money would have to go there to represent the damage, the loss in value, the use that he derived from it. So he would be liable in that regard. So that's minors. Those are the kind of some specific rules about minors. What about mentally incompetent persons? The first is, how do we know if somebody is mentally incompetent? Well, there are two tests. There's a majority test, which is the older test, but also the far more common test is the cognitive test, which says that what we're asking is whether at the time of formation, whether the person had sufficient mental ability to understand in a reasonable manner, and the key phrase is the nature and consequences of the transaction. Were they able to understand in a reasonable manner the nature and consequences of the transaction? That's the cognitive test, the majority test that's used. And there's also the volitional test, which hypothetically what the volitional test is getting at is there are situations where somebody may understand the nature and consequences of the transaction, but they may not be able to they may be impulsive, they may not be able to control themselves, prevent themselves from entering into that transaction, which is what volitional is trying to get at. Volitional, like a choice or will or voluntary. The idea that I'm not, because of a mental illness or disability, I'm unable to act in a reasonable manner in the transaction. And oddly, and I think to cause a bit of, duplication with other parts of mental incompetence, but the volitional test has built into it a requirement that the other party knows of that condition. They must know of it in order for us to go, yes, in fact, they satisfy the volitional test. The other thing to realize, though, with mental incompetence is somebody cannot always disaffirm the contract. They will not, if three things, right? What three things? If the agreement has been performed in whole or in part, the other party had no knowledge of the incompetence, which one of the things I was just saying is the volitional test kind of throws a wrench in things, because it's like, well, if you were following the minority test or volitional test, or using the volitional test rather than cognitive test, this makes no sense. Right? That because it's like, well, didn't I have to prove knowledge in order to do it? Yes, which is why I would say assume 9 times out of 10, the cognitive test is what we're going to be following. Okay. So the cognitive test, you're saying the other party had no knowledge of the incompetence and the terms of the agreement are fair. If all three of these things are true, and the reason this exists is because we want to protect mentally incompetent individuals, we also don't want to create unfair situations where the other party is not going to, the merchant or whoever who may be on the other side of the transaction may have no idea that the other party is suffering from a mental illness or defect, and yet they they've got a contract which can be disaffirmed. And so, but it can't be, if all three of these are true, if the agreement's been performed in whole or in part, the other party had no knowledge of it, meaning if it's a merchant and a mentally incompetent person, the merchant had no knowledge of it, and the terms of the agreement are fair. In other words, the merchant wasn't trying to take advantage of them. If that's the case, then what? It can't be disaffirmed, right? If all three are true, then a mentally incompetent person would not, even though they quote unquote lack capacity, they would not be able to disaffirm the agreement. So we can see an example. We go back to Bob here when he's suffering from mental illness, and but here, rather than an apartment, we're doing a car washing here for $30, and here, Bo is washing Bob's car for $30. He does so, and Bo says,
"Hold on, time to pay up."
And Bob says, "No, I'm not going to pay," right? He doesn't pay the $30. And Bo sues him for breach, saying, "I performed. You need to do this for me." Bob raises the defense of mental incompetence. We have to remember our special rule, right? Our special rule, which says what? These three things. If the agreement was performed in whole or in part, well, we'll go through these, right? Was it performed in whole and part? Did Bo have knowledge of the incompetence here? Are the terms of the agreement fair? we can go through these and go, there was part performance. Bo performed, right? He went ahead and washed Bob's car. Bo had no knowledge. There's nothing about Bob that would tip him off, right? That bubble would not be hanging over his head, right? That's just a way for me to indicate to you that he's mentally incompetent. But Bo has no knowledge, and that there's nothing, $30 car wash, sadly, is where we're at, right? That's about how much it costs. So that's a perfectly fair agreement. And so mental incompetence is not going to work as a defense, and that means Bo's suit will proceed, right? It will move forward, and he would be able to prove it out. So what about intoxication? We already said that the other party has to meet knowledge, but the other question is, well, what do you mean by intoxication? Just like with mental incompetence, we need a test, and there's only one test. We don't have to worry about the volitional test. The cognitive test is the one and only test for intoxication. And so the person has to say that they were so incompetent or so intoxicated that they lack the ability to understand in a reasonable manner the nature and consequences of the transaction. They have to meet that test to show that that was true because of intoxication at the time of formation. If it is, then they would be able to do it, but they need to show knowledge, right? Because with intoxicated persons, our concern is protecting them from being taken advantage of. So if the other person knew and tried to take advantage of them, then that's where we want the defense to apply. So if you think back to when Bo was intoxicated here, and Bob did exactly what we're saying you shouldn't do. Now is my chance to lock Bo into a lawn mowing contract that favors me. Remember, he entered into a $1,700 lawn mowing contract because Bob was trying to take advantage of it. That's precisely what I mean. This would meet here. Bo didn't know what he had done. He had a vague recollection of some sort of contract, and then he figures it out later. But he would be able to meet all the elements. And so that's it, right? That's lack of capacity. So we've looked at defenses to formation. That's where we're at, right in our framework. Did Statute of Frauds, looked at lack of capacity. Next time we'll look at duress and undue influence. So I hope that's helpful. Please like and subscribe. I appreciate all the support. Thank you so much. I'll be back soon with another video. The next one, as I said, on duress and undue influence. See you soon. Bye.